In my jurisdiction, one or more of the last three elements, those are the alternatives, the risks and benefits of alternatives, the risks and benefits of doing nothing, are frequently missing from motions and attachments to motions to mitigate. Moreover, the information supplied is often very summary and brief, leaving me with more questions than answers. For example, I frequently have questions about dosage, the range of dosage, the likelihood of occurrence of the more harmful side effects, and the need for multiple medications to treat the same symptom. Unfortunately, in most instances, due to the pressure of time, I'm usually forced to make a decision based on what information is provided, whatever conclusions I can make, and whether I know and trust the physician well enough to rely upon him or her without further information. And I believe that many of my colleagues throughout the state share this same dilemma. So when this happens, we judges are put in an uncomfortable position. Do we go ahead and make the best decision we can with what we've got, or do we seek more information? Seeking more information requires amended affidavits, perhaps a hearing, and perhaps even research on the internet. In fact, recently I've been getting many attachments of downloads from the internet, and some of them I find helpful and some I find not at all. But any additional information request will cause delay, and yet may turn out to be of no help or benefit at all. Because again, we are not experts. The questions we ask may be very, very naive questions, and then once we go through all that time to get the answers, we find out it isn't that useful after all. Finally, we have to be concerned about the extra effort we require from physicians. If we bog them down with too much paperwork, it may aggravate them to the point of refusing to take children in care as patients. Therefore, judges have to weigh the risks and benefits, because we do not want to waste people's time and unnecessarily delay vitally needed treatment, but at the same time, we also want to do what we're supposed to do, and that is make an informed decision. I recently convened a work group in my county, and the consensus that we reached is that what is most important for judges is that our system stakeholders come to know and trust the physicians hired to treat our children with mental health needs, much the same way as we form trusting relationships with our own chosen physicians. And I believe that most of my judicial colleagues would agree with that as well. I believe all judges wish they knew more about psychotropic medications. We could all benefit from more education, as well as some handy, effective references at our fingertips. We want to feel comfortable that our consent is informed and that the treatment is calculated to benefit children without doing any harm to them. Finally, we want to accomplish these goals without taking up too much of ours and the physician's valuable time. On the issue of over-medicating, most, if not all, of the judges believe that children in the child protection system who are on, let me go back. Most, if not all, judges believe the child protection system is medicating too many children beyond what is medically necessary for proper treatment of children's mental health illnesses and disorders. In some cases, we worry about whether the medication given to the child has crossed the line of good medical care and has become a tool to provide relief to others and not to the children. Because we're not physicians or pharmacologists, we can't prove over-medication. On the one hand, we may be alarmed to find a heavily sedated child on 4 different medications, only to find that he is getting first-rate medical treatment. On the other hand, a low dose of one psychotropic medication could be medical malpractice happening right under our eyes, and we are completely unaware and unconcerned. Judges should not withhold consent based on a hunch of over-medicating or on a personal philosophical opposition to psychotropic medications. We are not supposed to substitute our judgment for the physician's judgment because we do not possess the medical expertise. We are supposed to receive the information from the physician, receive input from any interested party, such as a guardian ad litem, and if necessary, conduct a hearing. Then we give our consent, either in full or with conditions or modifications, or we can withhold consent. However, a withhold of consent must be supported on medical grounds. The role of the judges is that of the substitute parent, not a substitute physician. The problem of over-medicating children with psychotropic medications goes beyond the child protection system. The courtroom is not the forum to stop it, but we believe that it happens with more frequency within the child protection system than outside. Nevertheless, this lingering belief affects the way we try to make judgments in the best interests of children. All we can say is that we know the problem exists to a significant extent, and we would dearly like to see it resolved to the benefit and well-being of all affected children. With those comments, I'd like to make 4 recommendations. First, that judges and other stakeholders in the system get more education on psychotropic medications. And I'm not talking just about pharmacology or pharmacology 101. I don't need to know about the molecular structure of a particular medication, but something that is useful. We need to know the different types of medications, what they're designed to treat, and get just a better feel for the whole idea of pharmacology as it relates to the work we do. Second, we need to develop best practices and procedures for obtaining informed consents, both from parents and from judges, and provide training to all the applicable people on those best practices. Third, I would like to see, and I understand this might be in the works, a good judge's desk reference, much like a physician's desk reference, but a good judge's desk reference that will allow us to quickly access important things we need to know. Fourth, perhaps even develop what I would call a bench card, which is just can even be a small laminated sheet of paper, which is an at-a-glance guide and will be used to essentially crystallize the most important things that we need to know, especially if we are conducting an evidentiary hearing. And those are my perspectives from the bench. I thank you for your attention.